You know, we've looked at some of the research here in Minnesota, and the cost of licensing to consumers exceeds a premium of $3 billion a year. That's just the extra cost caused by the loss of competition. In terms of jobs, we know that licensing is a barrier to entry. If you were to get rid of licensing and replace it with a certification system, you could instantly create 15,000 more jobs.
And we need jobs.
And we need jobs. We need jobs. We don't need TARP and we don't need Keynesian economics. What we need to do is get rid of regulations that block entrepreneurs, block those who want to become entrepreneurs. And so the Institute for Justice is focused in on these sort of licensing and permitting issues that have nothing to do with health and safety or are implemented under the guise of health and safety, but really are anti-competitive.
We saw during the state shutdown what a huge role licensing and permitting plays in the state of Minnesota, whether it was the beer companies or there were any number, the racetrack, Running Aces in Canterbury Downs. There was a paper company up in Duluth where licensing and regulation, permitting, it's out of control. It is out of
control. That was a great takeaway from the shutdown, that government has its hand in too many places, stopping legitimate, honest business people from pursuing business that is in demand. So we bang away at it on behalf of, in cases that represent the bigger issue of too much government interaction, too little freedom, and stopping people from, as your last point is, pursuing what is really the American dream. The idea that freedom is important for the realizations of one's potential. And that is what this country is all about.
Exactly. So did you win?
We did. Unlike Kelo, which we didn't win at the Supreme Court, but we won elsewhere.
Well, we won in other ways. And it happens like that sometimes.
But at the district court here in Minnesota, the cosmetology board threw in the towel.
Good.
They knew that they had no evidence that there was a connection between their requirement that our clients go learn how to do bouffants and the protection of consumers who want their hair braided.
Now, how do we get rid of the cosmetology board? Oh, that's a question for another day. Okay, a question for another day. You've had a lot of interesting cases, though, in your time here. Tell us about another one.
Well, one of the fun things is that we're often accused of not going after our own. Earlier this year, however, we were in front of the Minnesota Supreme Court arguing that the licensing of lawyers was too restrictive. And we told the Supreme Court that it should break up the cartel that lawyers have, in that in order to sit for the bar exam here in Minnesota, you only can attend an ABA accredited law school. Now in California, there are approximately 40 state accredited law schools. We had 3 clients who were graduates of those types of law schools in California, who had sat and passed the toughest bar exam in the country, the California bar exam, who in theory could be admitted to practice before the United States Supreme Court, but they could not get an opportunity to sit for the Minnesota bar exam because of this cartelization that exists between the 4 law schools, the Board of Law Examiners, and the American Bar Association. Fortunately, our clients were so compelling that the justices themselves changed the state's rules, the court's rules, and now our clients can sit for the bar exam.
That's great news.
So we think we were really pleased about that. Not only does it create more opportunity for our clients, but also it brought in front of the court this very issue that licensing is often enacted and maintained for anti-competitive reasons.
Mm-hmm. Well, that's a good one too.
So,
one of my favorite ones was the one down in Red Wing. Can you tell the viewers about the Red Wing case?
I can. In addition to economic liberty, we look to help people maintain their property rights. And government is constantly knocking on their doors, and you have the right to say no when they ask, may we come in? Well, the city of Red Wing took it upon itself to require all landlords to get a license that required an inspection of every single rental unit in the city once every 3 years. We thought that was crazy. We think the market is a much better protector of quality, of security, than some periodic inspection. And we also respected the rights of tenants to say, no, we don't want you, Mr. Government, to come into our rental units. So we have defeated 3 warrant requests for inspections because both our tenant clients and our landlord clients want to maintain their privacy. And so we've won so far in Red Wing. Now the question is, in front of the Minnesota Supreme Court, this we're waiting for an answer on, is can we get a court to declare the law unconstitutional? And that's an issue of, do we have standing? And we're waiting for a decision from the Supreme Court on that question. When we get it, either win or lose on that standing question, we'll be back in Red Wing fighting for the privacy rights of both our tenant and landlord clients.
So has that type of case been done in any of the other states?
No, it hasn't. We're on the cutting edge of this question of, can a municipality look to one part of town and say that is a basis for inspecting your rental unit where you live? We think that's wrong. If the government wants to get into your rental unit, it should have probable cause that something is wrong with your unit and not borrow the housing code violations or the probable cause from a different part of town. This is important for renters across the state of Minnesota, and we believe beyond that.
Oh, I do too. And then one of my favorite ones, because I got a chance to ride on a tractor, was the pumpkin farm. Another property rights case. Well, it wasn't really property rights. Tell us about that case.
It was an economic liberty case.
Yes.
And it was in Lake Elmo. And the city of...
Lake Elmo, that city. That city.
You don't like Lake Elmo?
I'm a little irritated with them. Now, the pumpkin farm deal was just part of it, but don't get me started on the library. But okay, back to the pumpkin farm.
In Lake Elmo, we represented a nursery, a Country Sun nursery, right on Highway 36.
Great people.
The Bergmans are great people.
And I got to say, what support did we have? All those tractors there, all those farmers, all those townspeople, all of us coming together. I'm looking at these tractors going, whoa, you know? And then the tractors all go down to City Hall for the board meeting. It was so much fun. Who
great.
Says you don't have fun?
And you were there,
yes.
And that was great. And so the city of Lake Elmo said to the Bergmans that they could sell pumpkins that they grew in Lake Elmo, but they couldn't sell pumpkins that they grew on their own property in Wisconsin. They could sell Christmas trees that they grew in Lake Elmo, but they couldn't sell Christmas trees that were grown in North Carolina by another farmer.
And what was the rationale behind that?
The rationale behind that is it's
stupid.
I think the city believed that they wanted to protect the rural nature of Lake Elmo. Well, those are admirable wishes, but you don't achieve that with the coercive force of government. And you certainly don't achieve it by violating the constitutional right to ship product on an interstate interstate basis from Wisconsin, from North Carolina. Oftentimes, city officials attempt to achieve admirable things, but they do it too coercively. They don't do it through persuasion or education. They do it through laws and statutes and ordinances and rules, and they're blunt instruments that really disadvantage their own residents, entrepreneurs, and consumers. In Lake Elmo, we have won that case, and the Bergmans will soon get their permit to be able to sell pumpkins and Christmas trees that come from Wisconsin and North Carolina.